I'm Lane Strother. I'm an attorney here in Mountain Home. I practice law with my wife, Judy. We've been in the Strother firm for almost 30 years. We have practicing it with us Bill Anderson, who is also a lawyer. I'd like to talk today about estate planning and basically what I consider to be the 5 components of a properly planned estate. These include a will, a living trust, a health care proxy, a death with dignity declaration, which is also referred to as a living will, and a power of attorney. I feel like every adult needs a will. Young married couples need a will primarily if they have children, to name the guardian for their children if something were to happen to both of them. Older adults, as they have accumulated possessions, homes, things of that nature, need a will to properly distribute these items to the people or places they want them to be distributed. I would encourage you to consider first who's going to be in charge of your estate after you're gone, who's going to gather your assets together, pay your bills, and then distribute everything. And that person normally is referred to as an executor. And then you also need to consider to whom you want your assets distributed after you're gone. And let's talk about that a little bit, especially for a young couple. The most important point there is to talk about a guardian for their children, their minor children, if something were to happen to both the mother and the father. And if you don't make a choice, then you're going to leave it up to a court to decide. And basically a court will usually make that decision in about a half-day or full-day trial. So if you've expressed your wishes, if this should happen to both my spouse and me, then this is whom we want to serve as the guardian for our minor children. And the second thing that I have discovered over the years is that if you don't specifically set a date for your children, your minor children, to receive their inheritance, then they will receive that inheritance when they reach age 18. And I don't know about you, but most of us at age 18, although we thought we were mature enough, usually even a $50,000 inheritance is gone before the year or two is passed. And we don't have the planning and the education and things like that that we need for a lifetime. Another factor that I often encourage people to consider is, do they have a charitable interest? And if they do have a charitable interest, then they can only provide for that through a will or a trust. Now, the other thing I think is very important is that every adult has a will. They either have a will that they have prepared, or they have one that the state has prepared for them. And most of us are not that anxious to let the state prepare the will for us, and so I encourage every adult to have a will. One of the big questions that a lot of people have in their mind is, if I do a will, then I will avoid probate. But the term probate actually means to prove. And so what you're doing is you're proving that this will is your last will and not some other will. And so you do, if you have a will, it goes through probate. If you die without a will, then your estate goes through probate to get to the heirs according to the state's will for you. There are several ways to avoid probate expenses. One is to own property jointly, and most husband and wives will own their property jointly. So one dies, everything goes to the survivor, no probate. A lot of times people will come in after a spouse has died and they say, let me put my son or daughter on my accounts so that everything will pass without having to go through probate. And I had not too many months ago a client in who said, well, that's what happened with my mother when she died. She left everything to my older brother. But my older brother died the next week, and his wife got all of his inheritance and all of my mother's stuff, and she said, "Goodbye, adios, I'm out of here." So I don't encourage people to put property in joint names because that sometimes happens, that one individual forgets to share it with his brothers and sisters for one reason or another. A second way to avoid probate is to have, in like a bank account, you can have it payable on death to somebody. On stocks and bonds, you can have that transferable on death. The problem here, though, again, the little square that they have on the form is not usually large enough to include all of your children or all of your beneficiaries, and it's also somewhat difficult to fill these out and make them all coordinate with each other. For instance, if you leave everything to, let's say, your 3 children, and one of your children predeceases you, does that child's children get that child's share, or does it go to the 2 surviving children? Because on the form, you just put the 3 names down and nothing else. So again, the best way, in my opinion, to avoid probate is to set up a living trust.